Hello everyone, I am Dr. Neha Sharma, Assistant Professor at the School of Legal Studies, KR Mangalam University. I welcome you to all to this lecture on one of the most foundational topics in Indian constitutional law, citizenship. Now, before we begin, let me ask you something. When you say I am an Indian citizen, what does that actually mean? Is it something having a passport or is it something deeper, something that connects you to the rights, identity and participation in democracy? Citizenship is not just a legal label, it determines your right to vote, your ability to hold public office, and your access to fundamental rights under Part 3rd of the Constitution. So, today we are not just studying provisions, we are understanding the very basis of belonging in a constitutional democracy. By the end of this lecture, you should be able to clearly understand five key areas. First, the meaning of citizenship, what it actually signifies in constitutional terms. Second, the constitutional provisions from Article 5 to Article 11. Third, the Citizenship Act 1955, which operationalizes this provision. Fourth, the modes through which citizenship can be acquired and lost. And finally, we will engage with contemporary issues, especially the Citizenship Amendment Act. And as you go through the lecture, if any concept feels unclear, please make a note of it. That's how a real learning can happen. So, what exactly is citizenship? Citizenship is a legal status granted by the state. It creates a relationship of rights, duties, and allegiance between an individual and the state. A citizen enjoys full civil and political rights, including right to vote, holding office, and claiming fundamental rights that are not available to non citizens. Now, an important point: the Indian Constitution does not define the term citizen, it only tells us who shall be a citizen. The detailed framework comes from the Citizenship Act 1955. There are also some key features that you should remember. India follows single citizenship, unlike countries like the United States, where you have dual citizenship at federal and state level. Second, Indian citizenship is secular in nature. It is not based on religion, caste, or ethnicity, at least constitutionally. And third, Parliament has the full power under Article 11 to regulate citizenship. Now, pause for a moment and think, is citizenship a right or is it a privilege granted by the state? I wanted you to reflect on this before we move ahead. So, moving to the constitutional framework, citizenship is dealt with in Part 2nd of the Constitution, covering Article 15 to Article 11. These provisions were framed in a very unique historical context, the partition of India in 1947. Massive migration was taking place, and the Constitution had to determine who would be considered as a citizen. Article 5 talks about citizenship at the commencement of the Constitution. It is based on domicile along with birth, parentage, and residence. Article 6 and 7 deal with migration from Pakistan, a very sensitive and complex issue at that time. Article 8 deals with persons of Indian origin residing outside India. Article 9 states that if a person voluntarily acquires foreign citizenship, they lose Indian citizenship. And finally, Article 10 and 11 that deals with the continuance of citizenship and give Parliament the power to regulate it. So essentially, the Constitution sets the foundation but leaves the details to the legislation. Now, let's test your understanding. Here's the question: which article deals with the rights of citizenship of migrants from Pakistan? Take a moment. Don't rush. Think about what we have just discussed. So the correct answer is Article 6. Article 6 specifically deals with persons who migrated from Pakistan to India. It even distinguishes between those who migrated before and after July 1948. This kind of detail is very important, especially for your exam purpose. Now, moving to beyond the Constitution to the Citizenship Act 1955. This act provides five modes of acquiring citizenship. First, by birth, but remember, the rules have become stricter after amendments in 1987 and 2003. Second, by descent, for persons born outside India, subject to conditions. Third, by registration, usually for persons of Indian origin or spouses of Indian citizens. Fourth, by naturalization, which requires residence in India for a prescribed period and fulfillment of certain conditions. And fifth, by incorporation of territory. For example, when territories like Goa and Sikkim became part of India. So you don't need to memorize blindly. Try to understand the logic behind each mode. Now, let's talk about how citizenship can be lost. There are three ways. First, renunciation. second termination, and the third is deprivation. Renunciation is voluntary. Termination happens automatically when someone acquires foreign citizenship. Deprivation is compulsory. It is imposed by the government in certain cases, like if someone has committed fraud or disloyalty. Now, let's apply this to a scenario. Suppose someone who is an Indian citizen acquires Canadian citizenship. She does not formally renounce Indian citizenship. What will happen? Her Indian citizenship is automatically terminated under Section 9. India does not allow dual citizenship. That is a very important topic. To begin with the judicial interpretation, we have the Berubari Union case, which is a landmark case where the Supreme Court dealt with the issue of cession of territory. It held that transferring Indian territory requires a constitutional amendment, which directly affects citizenship of people living there. In the State Trading Corporation case as well, the court made it clear that a company cannot be a citizen. Only natural persons are citizens. But here is an interesting twist. Companies can still claim certain rights like Article 14 because they are persons. So think about it. Can a company claim Article 19 rights? The answer is no. Pause and reflect on why that distinction is exists. Moving to the contemporary and debated issue, the Citizenship Amendment Act 2019. This act provides a fast-track path to citizenship for certain religious minorities from Pakistan, Bangladesh, and Afghanistan. However, it excludes Muslims. This has led to a major constitutional debate under Article 14, the right to equality. The key question is, does this qualification satisfy the test of reasonable classification? Is there an intelligible differentia? Is there a rational nexus with objective? Critics argue that excluding Muslim violates secularism and equality. Supporters argue that the law is based on persecution and not religion. Now, I want you to pause and think, where do you stand? There is no single correct answer. What matter is your reasoning. So, to quickly sum up whatever we have understood in this session, citizenship is not just a legal concept, it is your identity in a constitutional democracy. We covered Article 5 to Article 11 of the Indian Constitution, modes of acquisition and laws, key case laws, and contemporary debates. If you remember one thing from today's lecture, let it be this: citizenship is the gateway to rights, participation, and belonging. Thank you for watching. If you found this lecture helpful, do like, share, and subscribe to this channel. And I would really encourage you to drop your thoughts in the comments, especially on the CAA debate. See you in the next lecture. Till then, thank you so much. Bye.